If you entered the United States on ESTA, you fell in love, you married a US citizen, and you're thinking, perfect. I'll just go to my marriage green card interview and walk out with my approval. I need you to hear this loud and clear. In 2026, that green card interview can turn into the day you get walked out of the building and put on a plane, and you might not even get the chance to see an immigration judge to fight it. A lot of people hear visa waiver program and they think it's just a convenient way to travel. You don't have to go to the consulate. You don't have to wait for an interview. You don't have to bring stacks of documents to get a visa foil stuck in your passport. You just apply online for ESTA. You get authorization, you board the plane, and you enter. It feels easy. It feels friendly. It feels like you're being treated like a low-risk traveler. And many times it is easy, but that word waiver is doing a lot of work. And it's not just waiving the requirement that you obtain a visa, it's also a waiver of rights that visa holders usually have when the US government decides it wants you out of the country. To make this simple, let's talk about two people. I'm going to call one of them Elvis and the other one Victor. Elvis enters the United States on EST through the Visa Waiver Program. Victor enters the United States using a traditional non-immigrant visa like a B1, B2 visitor visa or maybe a student visa. Both are admitted lawfully. Both come through inspection at the airport. Both are here legally at the moment they enter. Now, both Elvis and Victor meet a U.S. citizen, fall in love, and get married. They both decide they want to apply for a marriage-based green card from inside the United States. They both think, we're married to a U.S. citizen. That's the strongest category, immediate relative. What could go wrong? Here's what could go wrong. The process and the protections are not the same, and the difference can be life-changing. When you enter on ESTA, you're normally admitted for up to 90 days. There is no extension. There is no change of status. The government's expectation is that you're coming temporarily, you're leaving quickly, and you're not trying to turn that trip into a permanent stay. That doesn't mean nobody ever adjusts status from ESTA. People do. Immediate relatives of U.S. citizens can often file for adjustment of status even after overstays, and many cases get approved. But the problem is, not just can you file. The problem is what happens if the government doesn't like something about your case, and what happens if they decide to enforce the rules in the harshest way possible. Because here's the critical legal reality about visa waiver. As part of entering on ESTA, you are generally giving up the right to fight your removal in front of an immigration judge with very limited exceptions. Most visa holders, if the government wants them removed, get placed into removal proceedings. They get a notice to appear, they get a court date, they get to stand in front of a judge, and they get the chance to ask for relief, to ask for time, to show that they have a pathway, to apply for bond, to have a lawyer argue their case, and to have a neutral decision maker decide what happens next. That's Victor's world. Elvis's world can be very different. If DHS decides Elvis is removable, he can be removed fast. And the path to a judge is often not there in the normal way people expect. That's why we're talking about this so urgently in 2026, because we are seeing more aggressive enforcement behavior in certain situations, including situations where someone shows up to a government appointment thinking it's just paperwork, and the government uses that appointment as a moment to take enforcement action. So let's walk through how this plays out in real life. Elvis enters on ESTA. He's admitted for 90 days. He meets his U.S. citizen partner. They get married, they decide to file the I-130 and the I-485, the whole marriage-based package, and they do it while he's still inside that 90-day window. Or maybe they file shortly after it expires. They might have good intentions. They might have a real marriage. They might have lots of evidence. They might have a perfectly approvable case. But when Elvis goes to his interview, USCIS is not required to approve the case on the spot. USCIS can continue the case. USCIS can issue a request for evidence. USCIS can separate the couple. USCIS can dig in on intent issues. USCIS can suspect fraud even if there is no fraud. USCIS can decide there's a misrepresentation issue. USCIS can find some old record. USCIS can decide the marriage evidence is weak. USCIS can decide the medical isn't right. USCIS can decide a prior overstay or prior trip creates questions. USCIS can decide a prior entry created immigrant intent concerns. And if USCIS decides not to approve Elvis and DHS decides to take enforcement action, Elvis may not have the normal procedural runway that Victor has. Victor, the visa holder, can also have problems at the interview. Victor can also get denied. Victor can also be arrested. Victor can also be placed into removal proceedings. Victor can also be put in front of ICE. All of that can happen, but Victor usually has something Elvis doesn't. A built-in system where the government issues charging documents and then a judge gets involved. Victor can request a bond hearing in many cases. Victor can fight the case while the I-130 is pending or after it's approved. Victor can ask the judge for time. Victor can show eligibility for adjustment. Victor can argue the equities. Victor can argue that the government should exercise discretion. Victor can have a lawyer litigate in immigration court. Is that fun? No. Is it stressful? Absolutely. But it's a process with steps, time, and a decision maker outside the enforcement agencies. Elvis on ISA can be treated like someone who already agreed in writing. If the government decides I have to go, I go without the normal court hearing. And once DHS is in that mindset, they can move quickly. That's the nightmare scenario. You attend what you think is a marriage interview, and instead it becomes an enforcement event. Now, I want to be careful here because some people listening will say, but I know somebody who entered on ESTA and adjusted status and everything was fine. Yes, that happens all the time. Many ESTA adjustment cases are approved. The point of this video isn't that every ESTA case ends badly. The point is that when an ESTA case goes sideways, it can go sideways faster and with fewer guardrails than a typical visa holder case. And in 2026, the risk calculation is different because of the enforcement climate and because of coordination that at a minimum people are reporting and experiencing in certain jurisdictions. More situations where an immigration benefit interview is not treated as a purely benefits-based event, but as a point where enforcement can be triggered if USCIS decides the applicant is removable and if ICE is available and interested. So what exactly is the danger moment? It's not marriage itself. It's not even filing itself. The danger moment is when you put yourself in a place where the government has both the information and the opportunity to act quickly. The marriage-based interview is one of those moments. You're sitting in a federal building, you're identified, your status history is in the file, your fingerprints are in the system. The government can make a decision and act immediately. If you're Victor, the visa holder, and something goes wrong, the most common pathway is removal proceedings, where you still have a chance to fight and a chance to ask a judge for time to pursue the green card process. If you're Elvis, the ESTA entrant, the government can decide you're done, and you may not get the same opportunity to slow the train down. And then we have to talk about the really painful part, the consequences after removal. A lot of people don't understand how quickly one bad day can turn into years of separation. There are different bars that can apply depending on the facts, and the details matter. One major set of bars comes from unlawful presence. If you accrue more than 180 days but less than 1 year of unlawful presence and then you leave the United States, you can trigger a 3-year bar to re-entry. If you accrue 1 year or more of unlawful presence and then you leave, you can trigger a 10-year bar. Those bars generally kick in when you depart. Then there are separate penalties that can attach when the government removes you, especially if it's done through a fast-track process or if the government alleges fraud or misrepresentation. Some removal mechanisms carry multi-year bars of their own, and the length can vary depending on the type of removal and the allegations. The point is not to memorize numbers from a YouTube video. The point is to understand that once DHS removes you, rather than you leaving on your own timeline, you can be looking at serious re-entry consequences layered on top of unlawful presence issues. And that can turn what you thought was a straightforward marriage case into a long-term separation and a complicated waiver fight. That's why I want you to stop thinking of ESTA as just a visitor entry. You need to start thinking of ESTA as a visitor entry where I gave up a major procedural protection if the government later decides to remove me. Now, let's address something else that causes confusion: timing and intent. A lot of couples meet, get engaged quickly, and decide to marry. Life happens, love happens. Sometimes it happens fast. The law doesn't say you can't fall in love on a trip. The law doesn't say you can't get married after you enter. But the government does care about what your intent was at the time you entered. If someone enters on ESTA saying, "I'm just visiting," while secretly intending to stay permanently and file for a green card, the government can treat that as a misrepresentation. That can create a whole separate layer of problems, including potential inadmissibility that may require a waiver. Intent is tricky because it's about what was in your mind at the time of entry. And the government often tries to infer intent from timelines, messages, wedding planning, and other evidence. So, when Elvis enters on ESTA and marries quickly and files quickly, USCIS may start asking questions like, did you plan this before you entered? Did you have a return ticket? Did you quit your job back home? Did you ship your stuff? Did you tell friends you were moving? Did you already have wedding plans? Were you already engaged? Did you come here to get married and stay? Again, many legitimate couples can answer those questions in a way that shows the relationship developed naturally and the decision changed after entry. But the shorter and tighter the timeline, the more scrutiny you should expect, and the more careful you need to be about getting competent legal advice before you file. And that brings us back to Victor. Victor might have intent issues too, but Victor's procedural protections, if the government challenges him, are usually stronger than Elvis's. So, what do you do with this information? First, if you are overseas and you are thinking, I'm going to use ESTA to enter, marry my US citizen fiancé E, and then I'll just stay and file, you need to slow down and talk to a lawyer before you do that. I'm not saying it can't be done. I'm saying you should not treat it as a casual plan because the downside risk is severe. Second, if you are already in the United States on ESTA and you are married to a US citizen, you need to understand that your strategy matters. Whether you file adjustment of status when you file, how strong the case is, what your immigration history looks like, what your prior travel looks like, whether you have any arrests, whether you have any prior overstays, whether you have any prior visa denials, whether you have anything in your record that could cause USCIS to hesitate or deny, all of that matters. A clean, well-documented case with a real marriage and no intent red flags is a very different case than a case with mixed facts, missing evidence, inconsistent timelines, or prior immigration problems. Third, you need to think seriously about whether consular processing is safer in your situation. Consular processing means you do the I-130, you get it approved, and then you complete the immigrant visa process through the U.S. consulate abroad, and then you enter the United States as a lawful permanent resident. For many couples, consular processing feels harder emotionally because it often requires time apart. But from a risk management standpoint, there are cases where consular processing is the safer route, especially if staying and filing inside the U.S. could put the foreign spouse in a position where a denial or enforcement action leads to a rapid removal. And I know what some people are thinking, but if I leave, I might trigger the 3-year bar or 10-year bar. Exactly. That's why this is not one size fits all. This is why you need individualized legal advice. Sometimes people would rather file inside the US because they're afraid of triggering a bar by leaving. But if filing inside the US carries a meaningful risk of a removal action that triggers other penalties and separates you anyway, you have to compare those risks honestly, not emotionally. There's also another dynamic that people misunderstand. Just because you file for a green card does not mean you are protected from enforcement in every situation. People assume the filing itself is like a shield. In many cases, it helps practically speaking because it shows you have a pathway. It shows you're trying to do it the right way. It gives the government a benefits process to follow. But filing does not magically erase the legal reality of how you entered, what rights you waived, and what DHS can do if they decide they want to remove you. So let's imagine 2 interview days, one for Elvis and one for Victor. Victor walks into the interview. The officer asks questions. The officer reviews the relationship. Maybe the officer is satisfied and approves. Great. But maybe the officer isn't satisfied. Maybe the officer suspects the marriage is not bona fide. Maybe Victor has a prior issue in his record. Maybe the officer says, "Oh, I'm not approving this today." Victor might get a denial. Victor might get referred to ICE. Victor might even be detained, but often Victor is placed into removal proceedings where his lawyer can ask the judge for time, can argue for bond, can keep the case alive, can fight. There is room to litigate. There is time to plan. There is a process. Elvis walks into the interview, same questions, same review. But if the officer decides to deny or decide that Elvis is removable, Elvis may not get that runway. Elvis might not walk out the front door. Elvis might be taken into custody and moved quickly. Elvis might not get a future court date. Elvis might not have the same path to bond. Elvis's family might be calling lawyers after the fact, trying to figure out where he is, trying to stop a removal that is already in motion. Now, is it guaranteed? No. Is it possible? Yes. And in 2026, it is a possibility that you must take seriously if you entered on ESTA. People sometimes ask, can a lawyer stop it? Sometimes, but it's hard. One tool lawyers sometimes talk about is filing an emergency habeas petition in federal court, essentially asking a federal judge to intervene. That is not a normal part of most marriage cases. It's extraordinary, it's expensive, it's fast and moving, it depends on the facts, it depends on the jurisdiction, it depends on timing, and the biggest problem is logistics. If DHS is moving quickly to remove someone, you may be racing the clock. Even if you have good arguments, you still need time to draft, file, get the case in front of a judge, and obtain an order before the person is placed on a plane. Sometimes that can happen, sometimes it can't. And no responsible lawyer should promise you that federal court will swoop in and save the day. The whole point is to avoid needing that kind of emergency rescue in the first place. So, what should you take away from this if you're watching? If you are a U.S. citizen dating or married to someone who entered on ESTA, you need to understand that your spouse may be more vulnerable than you realize. That vulnerability is not about whether your marriage is real, it's about the procedural protections they gave up when they entered on the visa waiver program. If you are the immigrant spouse who entered on ESTA, you need to understand that you're in a category that can be deceptively risky. People often think ESTA is the easy way in, and it is easy until it isn't. And when it isn't, the consequences can be immediate. And if you're still overseas and you're thinking about using ESTA as your pathway into a marriage green card, treat that like a serious legal decision, not a travel choice. The difference between entering on a visa and entering on ESTA can be the difference between if something goes wrong, I get to argue my case in court. And if something goes wrong, I might be gone before I can even explain what happened. I also want to say something directly to couples. None of this is meant to scare you into doing nothing. Doing nothing is often the worst plan. Overstaying without a strategy, without a filing plan, without legal advice, without understanding the consequences. That's how people stumble into the worst outcomes. The goal is not fear. The goal is informed decision-making. Sometimes the right move is filing adjustment quickly with a well-prepared package, strong evidence, and a clear explanation of the relationship timeline, especially if the facts are clean. Sometimes the right move is consular processing, especially if there are risk factors like prior immigration violations, questionable intent evidence, prior denials, or anything that might cause USCIS to deny and trigger enforcement. Sometimes the right move is to get legal advice before anyone travels, before anyone marries, before anyone files. because once you file and once you show up to the interview, you've set certain things in motion. And I want to underline something. The government doesn't have to think your case is bad in the way you think bad. USCIS can deny for technical reasons. USCIS can deny because of missing documents. USCIS can deny because they believe an answer is inconsistent. USCIS can deny because of a legal interpretation. USCIS can deny because they think there was misrepresentation. USCIS can deny because they think the marriage is not bona fide. USCIS can deny because they think you are inadmissible for a reason you didn't even know existed. In a visa holder case, a denial is devastating, but often still leaves a procedural path to fight. In an ESTA case, a denial can be the start of a rapid enforcement chain. If you're wondering, why would the government do this to someone who is married to a U.S. citizen? Remember, marriage to a U.S. citizen is a powerful basis for immigration benefits, but it is not an immunity shield. The government still enforces immigration laws, still investigates fraud, still applies inadmissibility rules, still uses discretion, and still coordinates within DHS. And the visa waiver program is designed in part to allow faster removals when DHS believes someone has violated the terms of admission.